Good morning, everyone, and welcome to today's Masterclass. I know many of you might be wondering if this is Sinesh speaking, but unfortunately, Sinesh is unable to make today's Masterclass. I have the honor of hosting our guest today in his place. My name is Jiroshan Naidu, and I am the Senior Segment Manager for Medium Business in South Africa. And I look forward to having an interactive engagement with everyone today. In today's Masterclass, we will explore a complex yet fascinating spectrum of law within South Africa. This session unlocks the need to know basics for your business to operate within the right side of the legal system within South Africa. With customers being protected so heavily by our legal system, it is vital to understand how your business can comply to different laws and acts within our legal system. Join us as we explore the world of legal systems for businesses in South Africa and give you the tools to secure your business and resources you need to drive growth and success responsibly as a legal citizen of South Africa. Our masterclass guest today is Kyle Torrington, who is a gentleman equipped with all the knowledge on our legal system for businesses in South Africa. Kyle is an established professional with degrees from the University of Stellenbosch and the University of Johannesburg. Kyle is a driving force behind Loft Legal and Legal Legends, with Legal Legends being the first legal e-commerce platform for quality legal services in South Africa. These services are aimed at businesses within the SME space, and during today's masterclass, you will witness firsthand how Kyle offers these services to SMEs through innovation, accessibility, and client satisfaction. Kyle is truly a thought leader within the space as he challenges traditional legal models with innovative models which are modern and logical. Can we please give Kyle, our prestigious guest, a nice virtual round of applause?
Good morning, Jay.
So, Kyle, thank you so much for making time for today's session. I think our guests are quite excited to, listen to you and your expertise. And I just want to also just mention to the guests that please do ask questions. We will have short breaks in between each one of the different topics that Kyle will cover today. So please feel free to ask your questions, and let's have the most interactive session that we can have. Thank you, Kyle. Over to you.
Awesome, Jay. Thank you for the introduction. Firstly, and I don't know if the viewers can see, just before this masterclass, my camera popped out my laptop and cracked. So the heavy blurring to my left is actually as a result of the crack as opposed to a blurred background. So I do apologize, but hopefully we can make it work. Today, I'm going to look at some of the common legal issues and considerations that startups face in South Africa. I'm going to stop after each section and ask for questions. And if there aren't any questions, I will just carry on. And hopefully we can cover as wide a diversity of legal issues or legal considerations that startups face. And hopefully it'll equip you to tackle them in future. All right, let's start. I'm sure that you can see my presentation. And no, it doesn't work. There we go. Okay. So as Jay mentioned, I am Kyle Torrington. I am an attorney of, I think, 14 years this year. I'm the co-founder of Legal Legends and Loft Legal. Legal Legends is our South African arm where we provide quality legal services on a fixed price e-commerce basis to startups and small businesses in South Africa. So I should be fairly well equipped to tell you what common legal considerations you will face as a South African company. Let's start out. So the first consideration you will be saddled with is deciding how to structure your entity. There are broadly three considerations. The first is a sole proprietor, the next is a partnership, the other is a private company. A sole proprietor is essentially a person in their own personal capacity doing business. So me, Kyle Torrington, am the business owner. I don't set up a separate private company and I invoice out of my own personal name. The same would be with a partnership. However, this would be two individuals coming together to form a partnership, but you still effectively, although you might invoice out of the name of the partnership, it's not a separate legal person, but it is two individuals coming together doing business in their own personal legal names. The third structure is a private company, and this is registered with the CIPC. This is very important, and I would advise that as soon as practically possible, you register a private company. The main benefit of registering a private company is that the assets of the company are separate standalone assets from your own personal assets. So this means that should there be any creditors of the company, they will come after the company for the debts and not you in your personal capacity. Whereas a sole proprietor or a partnership, any creditors can come after your own personal assets, such as your house or your car, to satisfy the debts of the business. A private company allows for a separate legal persona for this to not be permitted at all. Secondly, there are certain tax advantages where, as a sole proprietor, I don't know if you are aware, but as an individual, you have a sliding scale of income tax liability. A private company, however, has a standard income tax liability of 29%. So it makes sense from a tax perspective once you've, on a personal basis, gone above the 29% tier in your individual capacity to look at registering a private company so as to be taxed less. So if there are any questions about structures at this point, feel free to ask. I don't see anything as yet. So I will carry on until and unless something comes up. So let's say you've now set up your company. And let's say that you've got other shareholders or other partners on board. It is very, very important at this point to look at setting up a shareholders agreement and this relates very closely, an MOI. An MOI is a memorandum of incorporation. Now, certain of the aspects which a shareholders agreement or an MOI will cover are aspects such as equity divides, vesting schedules, roles of the different partners, come along and tag along provisions, rights of preemption, loans from shareholders, resolutions, specially protected matters, and restraints. I'm going to go over a few of these in a little more detail now. And I've selected what I believe to be the most important aspects. And to start off with, we look at vesting schedules. So very important. I would suggest that in the early days when you're starting out, especially if you have other partners, you don't know how committed the other partners might be. So what you look to establish is effectively a try before you buy situation where shareholders look at earning their shares over a period of time. Normally, it's 4 years. This basically protects the company by not having to give away shares in the early days that it can't claim back in situations where you might have a shareholder which leaves. So normally what happens is you say, well, listen, Mr. Shareholder, you're entitled to 10% of the shares of my company over a 4-year period, vesting at a rate of 2.5% per year. So each year they get an additional 2.5% in the company until they get the full 10%. However, within the first year, you get nothing. This is commonly known as a 1-year cliff, where no shares vest in that period. So if your partner decides to leave during that first year period, he gets nothing. No shares, no nothing, which at least puts you in a position where you've got what's known as deadweight equity, and you can continue with the business of the company quite easily afterwards. So this ensures commitment and obviously rewards long-term contributors of the company because these are simply shareholders which are willing to stay and are incentivized to stay. Come along and tag along provisions. These are very important. So a tag along provision in a shareholders agreement is it's a right which protects the minority shareholders of a company and allows them to join a sale. So what this means is, should, let's say, the majority shareholders of the company, say 75% of the company, wish to sell their shares, the minority 25% can go, hold on, I'm forcing myself to join that sale because I also want an exit at that particular point in time. Because if my majority shareholders leave, I don't know how well the company might be run, or I just want to be a part of the sale. That is what's known as a tag along. Then there are come along provisions, which effectively require a minority of the shareholders to also sell their shares in the instance of a sale. So let's say, once again, you've got a majority of 75% of the shareholders of the company looking to sell their shares. They can say to the minority, listen, Mr. Minority, we are forcing you to come along and also sell your shares. And this allows the majority to sell the entire company to a third party. So this ensures fair treatment and obviously exit opportunities between all shareholders. So very, very important, these provisions, which are fairly standard in a shareholders agreement. Then you've got rights of preemption, and this effectively gives existing shareholders the first right to buy shares of a selling shareholder. For example, you don't want, in instances where you've got a separate share, where you've got another shareholder in your company, you don't want them to sell their shares to any Tom, Dick, and Harry without first offering the sale to you. So that is what's known as a right of preemption or a right of first refusal. And this obviously ensures that unwanted shareholders do not come on board. And then there are resolutions of a company. So with shareholders, by default, ordinary resolutions or ordinary decisions of the company are passed by means of having an excess of 50% of the voting rights of the shareholders vote in favor of a particular decision. For the most important decisions of the company, at least 75% of the voting rights of shareholders need to vote in favor of a particular decision. So these thresholds can be changed, provided there's always a 10% difference between them. So for example, let's say you are a majority shareholder of the company holding 65% of the shares of the company, but you want to ensure that you remain in complete control of the company. Before bringing on a new shareholder, you can say, well, listen, just in the MOI, my special resolution threshold from 75% to 65%, the ordinary resolution threshold can remain the same, but at least I know that if it is reduced, if decisions are, or if special resolutions are reduced to 65%, I will have full control of all the decisions of the company. So that is very, very important to note that you do have that control. Are there any questions, or shall I move on to the next part of the presentation? I'm just having a look at my other screen here where I've got the presentation airing. No, I don't see anything, but feel free to ask when you have the chance. Now on to protecting your intellectual property. So you will see in a number of my slides, there are QR codes. This, for example, is a QR code to the intellectual property section on our website, where you can read more about trademarks, copyrights, and patents, as well as the cost to register and enforce various aspects of intellectual property. So I'm going to explain to you in a little bit of depth now the difference between trademarks, copyrights, and patents, because to be honest with you, quite often businesses are very confused between what constitutes what. So first, let's look at trademarks. Trademarks is essentially a sign which serves to distinguish the products or services of yourself from that of others. So for example, you can have words, phrases, symbols, logos, certain designs, or a combination of these, which would comprise your trademark. For example, the wolf symbol or logo that you see on the slides, that is our logo. That is a trademark. That is our trademark. In addition to that, the name Legal Legends is our trademark. If you have a product name, for example, let's look at Microsoft Word, that also is a trademark. So it helps consumers to distinguish between different products and services in the market. So although there are what are known as common law trademarks, which in some instances don't need to be registered, you have far greater protection if you look at registering your trademark with the CIPC. But just to note, a lot of people think that, well, in registering their trademark in South Africa with the CIPC, they have worldwide protection of their trademark. The reality is that it's not the case. Trademarks apply on a there are a few exceptions where there are a number of countries where you can register a trademark across a number of countries, but South Africa isn't party to any of those. So effectively, you have to look at registering trademarks on a per country basis. So this means that, for example, my brand, Legal Legends, there could be an identical trademark overseas in another country registered there, also called Legal Legends, where you will both have the same respective rights in those countries. So just take note of that. So with regard to infringement of a trademark, if somebody else looks at using something of a trademark which is identical or confusingly similar to my trademark, then I would be able to, in terms of the Trademark Act, stop them or prevent them from using that trademark. So somebody else providing legal services most likely could not use the word legal legend or legally legends, because those would be regarded as confusingly similar, and that would be regarded as infringement. Now, onto copyrights. So a copyright is effectively legal protection for original works of authorship. So these include things such as literary works, musical works, dramatic works, choreographical works, pictorial, graphic, sculpture, movies, sound recordings, and architectural works. Also, software development such as source code. So examples of this, or more practical examples, might be a blog post. Any blog post that you write, that automatically would be protected by copyright. Any source code that you put together for a website, that would be protected by copyright. Even the look and feel on the front end of your website, the colors that you use, the pictures that you use, provided that you are the original author, those would be your copyright, or at least the subject of a copyright. So in the vast majority of situations, copyrights don't need to be registered or can't be registered in South Africa, apart from one or two exceptions for films, but for the vast majority, they aren't registered. So as soon as you create them, they are subject to the protection of a copyright. So this provides a copyright owner with exclusivity as to the rights of the reproduction, distribution, performance, and display of their works. So they effectively have the entirety of the say around what might happen to their blog post or their logo, and anybody who uses their copyright in a manner that is not approved by the copyright owner would be regarded as an infringement. One thing that is very important to notice, a lot of people outsource the design, for example, of a website. Generally speaking, if you outsource any works which are going to be to an external service provider who's going to create something which is the subject of a copyright, such as an external blog writer or an external logo designer or an external software developer, by default, that external party owns the copyright to that work, unless you have a written copyright assignment agreement in place. And this is so important. I've seen, especially with regard to software development, where a software developer holds a startup at ransom because they have been appointed as an external service provider to develop the website, and they know that they own the copyright to it, and they know that they can hold a person at ransom and not release the source code of that website or the website itself to the startup or to the company until certain fees are paid. So extremely important. Every single external service provider that's going to create copyrights that you should own, you need to have a written copyright assignment agreement in place. And that QR code there is a link to a template on our website if you'd like to download it. It is a small charge, but you are able to use it for any copyright assignment that you might encounter in practice. Then there are patents. So patents are essentially, it's essentially legal protection granted over an invention or an inventive step, giving the inventor exclusive rights to use, make, and sell the invention for a limited period of time. The invention needs to be new and not known to anybody else, and it can't be obvious in the way for an ordinary skilled person in that field. So it really, really has to be a new invention. For example, a new hinge on a chair, or a new kind of engine utilizing a new kind of fuel, for example, that simply isn't around anywhere in the world. And if that invention, or if you do have that invention, or you have created that inventive step, you would be eligible to file for a patent with our CIPC. And that concludes the intellectual property section. If there are any questions, please feel free to ask. I don't see any questions currently.
Hi, Kyle.
Yes.
There is actually a question. There's two questions, actually. Kim's asked a question.
That? Sorry, I thought it was under the comments section.
Yeah, I'm not sure why it's popping up, why it's not popping up there, but it is actually under the live stream. So
Sure.
One of the questions that is being asked is, how do you determine if intellectual property is eligible for patent protection?
So you need to look at it. You need to decide, first of all, is it an invention that nobody across the world has seen? Number one. Is it obvious? Basically, is what I've created simply, for example, new use of existing technology? That wouldn't be regarded as a patent. So it's quite hard to give you an exact criteria, but you need to be of the opinion that what you created is an invention. It's not simply a discovery. It's not simply you taking all sorts of open source software and putting it together in a new way, for example, but it truly constitutes an invention that nobody has seen worldwide. Apart from that, it's very hard to provide sort of hard and fast steps, but I must be clear at this point, I'm not a patent practitioner. I'm an intellectual property practitioner, but patents are very, very specialized. So they might be best asked to a specific patent practitioner, but that is to the best of my knowledge, the test.
Okay, and just to follow up to that is, can you enforce intellectual property internationally, or is it something that can only be done within South Africa or a specific country at a
Yeah.
time?
So generally, with copyrights, you can to a certain extent, but generally, no, unless your intellectual property is registered in that country. So I, for example, can't have a trademark here, Legal Legends, and go to some chap in France who's using the same name and enforce my name, Legal Legends, as against him as an infringement, unless I, for example, registered at some stage my name in France and had a real intention of using it in that country. But yeah, generally you can't. Oh, those are two
Perfect.
questions? Oh, now
Yes,
they're coming up on the side. Okay. Are you going to read them out, Jay, or must I go through the questions?
I can definitely read them out for you, and then you can answer them. So I think one of the other questions that's been asked are, what are most common mistakes SMEs make when setting up their businesses and drafting contracts, and how can these be avoided?
Yeah, so, okay, drafting contracts, I'm going to touch on the contract drafting just now. But in terms of contract drafting specifically, the biggest mistakes I've seen are contracts which are drafted by business owners which have no idea of how contracts should be drafted. And what people don't realize is that if you have a contract which is drafted by yourself and it doesn't include, for example, a specific clause which says no representations or warranties outside of this contract are binding, people often have discussions and phone calls outside of the contract itself, and they don't realize that to the extent that certain things are agreed or discussed over the phone and there appears to be an agreement, it actually alters the written contract that you've entered into to the extent of what you've spoken about over the phone or separate to the contract. So very important is having it drafted properly and including that provision, because that provision ensures that whatever's spoken about outside of the written contract itself is never enforceable as part of the contract. So I see that very, very often. Just make sure that that clause is in a contract or that it is drafted properly.
Perfect. I think
When
there's one
setting up,
last
sorry,
question.
yeah,
Oh, sorry.
sorry,
Yeah.
yeah.
Sorry to
I was going
interrupt.
to say, an important mistake I see a lot of people doing when they set up their business is they go to the CIPC, they reserve a company name thinking that they've got all the rights to that name, but they don't realize that the company name register and the trademark name or the trademark register do not talk to each other. So you can register a company name, think you've got the exclusive rights to it, but somebody might own that trademark and prevent you, and it might be some months or even years down the line, come after you and prevent you or require that you change your name because you didn't do a search and register a trademark at the same time that you register the company. So that is something very, very important.
Okay. Then thank you for that insight, Carl. I think the last question before you can move on is, what action should we take if we suspect someone's infringing on our intellectual property rights?
Yeah. Well, it depends on what kind of intellectual property, but the first step is normally to send them a letter of demand. Identify who it is, address a letter of demand to them, demanding that they stop, and hopefully you get a response from them and you can engage in some sort of dialect to get them to stop. Failing which, the only way to force a person or an entity from utilizing your intellectual property is to go to court and get a court order. And that can be quite drawn out, but that is the only proper way to enforce intellectual property infringement.
Perfect. Thank you, Kyle. I think
Cool.
you can move to the next section now. Thank you, sir.
Okay, on to the next section now, contracts with clients and suppliers. Now, it is always very important to set legally binding expectations between yourself, your business, and your clients. And this is done by way of written contracts. And I would always suggest, for example, that you set these expectations in a manner where they are legally binding so that there's no chance of a dispute at a later stage, that people have a very good idea of what their obligations are, that there are time periods, for example, for deliverables, time periods for payments. Otherwise, without a written agreement in place, it really is the subject of ambiguity, and people might simply not know what is expected of them. So it is very, very important that you look at having written agreements with all your clients. This might, for example, be if you have a services company, a service level agreement with your clients. If you have an e-commerce website, this might be terms and conditions on your website, which set out delivery times, return policies, and all the like. That QR code in the screen is just a link if you'd like to check it out to a service level agreement on our website, where we effectively custom prepare a service level agreement for you. By the same token, also very important to have contracts with your suppliers to create legally binding expectations by way of a written agreement. This is especially important, and I've seen it before in practice, where you've got a supplier to your business and you in turn are relying on that supplier to provide certain services or products to your own clientele. Now, if the supplier does not have a written agreement and there are no expectations, it could severely hamper your ability to keep to your obligations in terms of your client contract. So setting expectations, setting delivery times, setting terms of the contract, setting payment terms with your suppliers are incredibly, incredibly important. That comes to an end the client and supplier contract part of the presentation. If there are any questions, Jay, you just pipe in and let me know, please. Then just moving on to operating a website. Now, most of you, I would think, will have a website that either just provides information about your business, or it might be an e-commerce website where you sell things through it, or it could be any number of websites or number of forms of different websites. Now, generally speaking, in order to properly operate a website, I would suggest having 3 documents in place. One is a website terms of service. The other is a privacy policy, and the third is a PI manual. Now, website terms of service effectively sets out the expectations between you and the users of your website. It could, for example, if you're an e-commerce website, set out delivery times to deliver the products. It could set out a returns policy. It could set out payment terms or payments you accept, and as well as any number of other aspects about the client relationship. Very, very important to have that in place. The second being a privacy policy, and I will go over this in a little bit more depth further on in the presentation, is something that's required in terms of the POPI Act, and is the mechanism that you get the consent of your users to collect their personal information and use it. The third is a PI manual, which is related to a privacy policy and is basic. It's required in terms of the PIA Act, the Promotion of Access to Information Act, and it is the mechanism that users can use in order to request a record containing their personal information. I will touch on that a little bit further on in the presentation as well. Now, on to POPI compliance. I'm sure that a number of you have heard about POPI, so I'm going to touch on the most common processes and documents that you require, that you need to have in place in order to be POPI compliant. Now, basically, if you collect any form of personal information in your business, you need to comply with the POPI Act. And you will see shortly this is very broad. In essence, you can't do business without collecting personal information. So you as a business owner will be required to comply with the provisions of POPI. Now, in order to determine whether you collect personal information, let's look at what the definition of personal information is in terms of POPI. Basically, personal information is any information relating to an identifiable person, whether living or an existing juristic person. So even a business could be regarded as a person. That's what a juristic person is. So examples of personal information might be aspects around race, gender, sex, pregnancy, marital status, nationality, education, medical records, criminal history, identifying numbers, symbols, email addresses, names, addresses, biometric information, personal opinions. I mean, the list goes on and on and on. And really, the net is cast so wide that to think that you might be conducting a business of any size without collecting any forms of personal information, you are incorrect, and you will be collecting personal information. So you need to, so the test is always to determine whether you need to comply with POPI. Number one, are you collecting personal information? And number two, are you processing that personal information? So now we need to look at what the definition of processing is. So it is, once again, the net is cast very wide here. Any activity concerning personal information, such as the collection, receipt, recording, organization, collation, storage, updating, modification, retrieval, alteration, and consultation or use thereof, or disseminating it, transmitting it, distributing it, and the like, merging it, restricting it, degrading it, and basically the litmus test is if you've got or are able to access any form of personal information, you would be regarded as processing it. So if you are processing personal information, you're required to comply with POPI. Now, in order to comply with POPI, there are certain grounds in order to lawfully process personal information. I think there are 6 in total. However, the most important ground that most of you will most likely deal with is consent. Basically, in order to process the personal information of any person, you're required to obtain their consent. An example of this would be when we chatted about websites is your privacy policy. Your privacy policy on your website is the method that you obtain the consent of what's known as a data subject, the user on your website, to process or use their personal information. You might, for example, have a form on your website where people fill out their email address and their name and ask you a question for you to reply at a later stage. You're processing their personal information, so they would be required at that point to consent to your privacy policy. There are a number of other grounds, but I don't think it's necessary to go into too much depth, but you can see them on my slides here, and I do believe they are going to be uploaded on your resource database. But for the purposes of this presentation, the 5 other grounds I don't believe are of as much importance, because in most instances, businesses will normally be required to obtain consent rather than rely on any of the other 5 grounds. Now, what are the typical processes and documents to put in practice to comply with the POPI Act? First of all, every single business, no matter what size you are, needs to register their information officer. Basically, an information officer is responsible for encouraging the compliance by the body of the conditions pertaining to the lawful processing of personal information. They also need to deal with requests made to the organization in terms of the POPI Act. They also need to work with the regulator, which is basically the government's enforcement arm of POPI, in relation to investigations. They need to develop a compliance framework in terms of POPI. They also need to conduct a personal information impact assessment report, or at least get a law firm, for example, to conduct such an impact assessment report. Then they need to ensure that a PIRE manual is developed, monitored and maintained. And as mentioned, a PIRE manual is essentially the document which sets out the process by means of which people can request your entity to divulge records which contain their personal information. And then the information officer needs to ensure that internal measures are developed together with adequate systems to process requests in terms of the POPI Act. And then they just need to ensure that internal awareness sessions are conducted. Very important. Every single organization needs to register an information officer. At this point, are there any questions around POPI, or should I carry on through the entirety of POPI before taking questions, perhaps?
I think you can carry on with the entirety of POPI, and then we'll take questions at the end.
Cool. Once again, there's a QR code on the slide. We do offer information officer registrations if you would like to explore that. Now, the next document, and there are various names for these, is a POPI policy or privacy statement. This is generally a policy, which is an agreement entered into between your business and its clients or suppliers, agents, independent contractors, and other parties if you collect their personal information. So once again, any single piece of personal information that's collected from them, you should have a POPI policy in place, or you're required to in terms of the POPI Act. So it is the mechanism in order to obtain their consent and regulates the manner in which the personal information may be collected, accessed, processed, and in some instances shared. So there's a link, QR code, if you'd like to explore the POPI policy on our website. Then there's a POPI Act workplace policy. So effectively, this is an internal policy which binds your staff members to treat the personal information that you collect on behalf of your customers and suppliers in the manner that you have promised your customers and suppliers as to how you will treat that personal information. Again, there's a QR code if you'd like to see that on our website. Then there's a data breach policy, which effectively sets out how you and your employees should deal with real or suspected breaches of data that you hold, and make sure that the correct procedures are followed to report and contain these breaches. Then, and we've touched on it a few times, is a website privacy policy. And this is the mechanism through which you obtain the consent of your website users to process their personal information, share it if required, and sets out who's going to have access to it and how you will utilize that information. And once again, there's a link to the privacy policy service on our website. Then there's something known as an operating agreement or a data processing agreement. So now, if your business requires any outside party to use or store personal information on your behalf of your clients or suppliers, this requires a written agreement. Very important. It is a written agreement known as an operating agreement or a data processing policy. Excuse me. And it needs to be entered into between your business and the outside party that is processing this personal information on your behalf, and effectively sets out exactly what that outside party is allowed to do with that information, strictly in accordance with your instructions. Again, there's a QR code if you want to see that service on our website. Then there's a PIRE manual, which we've touched on before, and this needs to be displayed on your website. And it sets out the how, when, and in what instances third parties are able to obtain access to a record held by your organization, which might contain their personal information. Then there are employment agreement addendums. So basically, these are addendums to employment agreements enabling your employees to consent to the processing of their personal information. Because obviously, by necessity, you would be collecting the personal information of your employees. And always, or in many respects, there is another ground of lawful processing which you could perhaps rely on, but it certainly helps to rather get their consent. And this is the manner in which you get the consent of your employees to obtain or to process their personal information. In some instances, this can also be included in the employment agreement itself, but very important. And lastly, if you would like to check out our POPI checklist, it's a free checklist questionnaire on our website. You can go through, answer a number of questions, and it will tell you how POPI compliant you are and what processes you might need to have in place. You can visit that link there. Gosh, and that's that. I thought it would take me quite a bit longer to get through everything, but yeah, that's the end of my presentation. So feel free to ask any questions that you may have.
Thank you so much, Cal. I think it was a very insightful presentation. You've taken us through quite a bit. There is one question that has come up. So business owners usually struggle with policies to protect their business from employee-related issues. How does one go about setting up policies to that ensure the business is fully protected?
So often to set up policies, I would suggest go to an employment law firm or a law firm itself who has a lot of these base templates in order to properly set out the correct policies between you and your employees. So instead of reinventing the wheel yourselves, go about getting them put in place properly. And you can also customize those to the extent that you require for those to specifically fit within your organization. But don't reinvent the wheel. Use a firm, get it done properly, have proper binding expectations for your employees by means of policies compiled by the correct personnel. If that answers your question, I don't know if it does.
Perfect. I think you've answered quite well. Thank you, Kyle. Just to mention to all the viewers, we will also be sharing the slides with everybody. So you can definitely look at the different QR codes that Kyle has provided and read up more about what Kyle's actually discussed today. And that's due to the fact that, legal is very specific to specific businesses. So certain laws apply to certain businesses, and certain laws may not necessarily affect your business. So I think that's something that you can investigate a little bit more.
Yeah, and this is very broad overarching. Obviously, there are industry-specific businesses which require a whole lot more compliance, where that might be governing or regulatory bodies. There's also tax-related compliances. There's obviously financial-related compliances, which I haven't touched on. So please just understand that this is just touching the surface.
I also have a comment here. So the comment reads, "Dear host, just a comment here.
Mm.
As a legal consultant, I have used legal legends with success. Most small SMEs
Awesome.
don't use proper legal contracts."
Yeah, that's correct. And what is so important is to rather invest up front in a proper legal contract, because that will save you in the long term with disputes, with ambiguity. And I promise you, it really is worth the money. It really, really is.
So typically, how much would this cost, Kyle, if you have to give a rough estimate?
Of all of that, what do you
Sorry.
mean? So you're talking about a single
So basically,
contract?
to create your legal contracts. So how much
So I
would
mean,
an
it
SME
does.
typically need to budget to ensure that they can have a legal contract that
Yeah.
you draft?
So we've got certain varieties. We've got some templatized contracts, which are made for you to fill in blanks. Those are anywhere between sort of 700 and 950 Rand. Custom contracts, it does vary quite widely. You're looking, I can't speak to other organizations, which are normally quite a bit more expensive, but we charge normally between sort of 6,800 Rand to about 9,200 Rand, unless it is super complex or it involves a number of different contracts.
Yeah, but I think it may be seen as expensive, but ideally it's protecting your business and making sure
Yeah,
that you have that going
yeah,
concern in the future as well.
yeah.
Kyle,
It's
I've
an
actually been
investment.
getting. Sorry, Kyle?
No, I'm just saying it's an investment to prevent
Yeah,
issues
definitely an
further on.
investment. Kyle, so we have two questions that actually have come on. So Beta said, "Thank you very much for the presentation. I would like to know, what advice would you give to a consultant or an individual that wants to offer their services to customers X such that their rights are protected? Example, this person's a consultant and can see that they want to sell their idea to a company."
Sorry, let me just read that. Sorry, I'd like to know what advice you'd give to a consultant individual that wants to offer their services to customer X such that their rights are protected, e.g., this person or consultant can see that they want to sell their idea to company X. Hold on. So you've got a consultant that wants to offer their services to company X, but the example is this consultant can see that they want to sell their idea to company X. Oh, so you're saying that customer X perhaps wants to look at selling the idea to company X. I'm taking it that customer X and
I
company
think
X are
that's
two different.
probably, yeah, that's also how I'm
Uh,
understanding it. So,
yeah.
yeah.
Okay. Well, certainly. Well, first of all, I'd advise of a service level agreement between you and, or between the consultant and customer X, and that service level agreement very specifically needs to speak to an intellectual property provision, that all the intellectual property rights created in terms of the services agreement are the consultant's property and cannot be sold or used or otherwise reverse engineered, as well as any other background intellectual property would also be owned by the consultant. And in that manner, you would be able to prevent, at least contractually, the other contracting party, customer X, from utilizing or selling your intellectual property or the consultant's intellectual property.
Thanks, Cal. There is one last question that I see here. So, what are the critical steps that SMEs should take to ensure compliance with POPI Act? And what are the potential consequences for non-compliance for businesses?
Yeah. So apart from what I've gone over in terms of putting all those documents in place and processes in place, and I'd certainly suggest trying out our free POPI health check on our site. Put those documents in place where required. But then you should also be looking at doing what's known as an impact assessment. You are meant to, in terms of the POPI Act, look at all aspects of your business, all touch points where people and different departments collect personal information and determine what might need to be in place, what is lacking, and what you do have in place. That's what's known as an impact assessment. You have to put that in place. Apart from that, what I touched on in the poppy part of my presentation, effectively for most small businesses covers what you need. Consequences for non-compliance is, I think there's a fine potentially of 10 million Rand coupled with a jail sentence of up to 10 years. So there are very material consequences, although we haven't seen too many of them actually being imposed, but they are material.
Okay, maybe a question from my side on the back of that, comment with regards to a jail sentence of up to 10 years. I know you mentioned in the beginning of the presentation sole proprietors and partnerships, and then you had your private companies. In the case of a sole proprietor and a partnership, I'm sure the owners of the business would then be liable for that 10-year prison sentence. But with regards to a private company, who would be liable for that 10-year prison sentence? Would it be the officer or the poppy officer or the compliance officer, or would it be the owner of the business?
Yeah, so it would probably, well, maybe not necessarily the owner, unless the owner is also a director and actively not involved in the poppy, and actively involved in not complying with the Poppy Act. So there are certain provisions in the Companies Act where if directors or officers of the company do not comply with their fiduciary duties, which are required of them, they can be held personally liable. So what would happen is the information regulator would look at who was responsible or should have been responsible for the non-compliance, and they could be held personally liable, in addition to the company itself. So most likely directors, certainly officers, the information officer itself or themselves, and the company.
Yeah, but definitely a risk that we want you not to take as a business. Let's not find those answers out, the hard way. So I do see there's a follow-up comment from Beta. She has said, thank you very much for responding. So does this mean that the agreement you were talking about has to be in a written format and also be signed by witnesses from Company X and the consultant?
So written agreements, apart from if you're selling property, don't have to be in written format, but it's actually quite ridiculous not to have a written agreement, because if you've just got a verbal agreement, then you just land up in a he said, she said scenario, and you can't enforce or prove anything. So I would 100% recommend a written agreement. However, apart from one or two exceptions, such as a will, and I also believe sale of property, you don't need any witnesses to an agreement. As long as the contracting parties sign, you don't require witness signatures in the vast majority of cases. Nor are you required to initial every single page, just the signature page is required. Or just the signature of the signature page is required.
Perfect. Kyle, I just want to thank you. I think we are done with questions. Maybe I can just hand over to you for any closing statements before I can just close off today's masterclass. Is there anything that you'd like to maybe mention or speak about before I can close off?
Yeah, I think obviously with legal compliance, it can sound very daunting. I mean, I'm also an entrepreneur myself. Maybe putting more my entrepreneurial hat on, you've got to weigh up compliance with the necessity to get product market fit and try and earn an income from your services. So always balance that. I would say take a staggered approach to compliance. Do what's absolutely necessary at the start, find traction, and then deal with aspects which might not be absolutely required. Just do that over time, because you don't want to drown your business in compliance related issues and never get to a point where you are able to earn an income that allows for the business to survive. So balance.
Thank you, Kyle. You've taken quite a bit of your time out today. So thank you for sharing your wealth of knowledge and giving us an understanding of legal matters in South Africa today. We hope that all Thank you so much. Yes, sir. So, yeah, we hope that all of our viewers have gained valuable insights into the dynamic legal system within our beautiful country. Remember that protecting your business legally allows you to have a going concern for your business, and it protects your business as well as your customers. With the knowledge you have gained today, we encourage you to research certain acts and legal terminologies, which will help your business grow and stay protected. With that being said, it's now time to conclude our masterclass around legal matters. And we look forward to hearing from all of you regarding this masterclass, as well as what you'd like to see in future masterclasses. Let's keep learning together through our SME platform called VHub, which gives your business advice on numerous aspects of business. There's a wealth of expertise and insights waiting for you to explore. I'd like to end off today with a quote. Jerry Greenfield, the founder of Ben& Jerry's ice cream, once said, "When you support a small business, you support a dream. We want to make your dreams a reality as Vodacom Business." Thanks for giving us your valuable time today, and we look forward to hosting you for the next Fast Forward series. Thank you, everyone. Have a lovely day ahead.